Welcome to Radio Free New York. I'm Kevin Wilson, hosting today. Andrew Hollister is out on vacation, so I'll be in for the next few days. Thank you, everyone listening to Radio Free New York out on WYSL or our other stations, WACK out in Newark, WENY, The Patriot out in Newark. Of course, on our Facebook page, Andrew C. Hollister, and Radio Free New York, our YouTube channel, our Twitter page, and of course, our podcast as well. Make sure you catch those podcasts. We're on Apple Podcasts now. We're on Stitcher, Castbox, or whatever podcast you listen to. Anchor is where we record ours or post ours. Subscribe to our podcasts there as well if you're not able to catch these live shows. And if you ever have any feedback for us, send us an email, contact@radiofreenewyork.com. Now we've gotten out of that out of the way, today's topic is states' rights. This is a big topic that I see come up a lot in conservative and libertarian circles. It's something that I see people talk about kind of in opposition to the power of the federal government. And it can mean a lot of things depending on who you're talking to and what issue they feel that states' rights are important. But I mostly see it in conservative and libertarian circles, although we'll get to some other ways in which it's been applied throughout history and the ways in which it's applied today. So I want to talk about what does states' rights mean. I want to talk about the Civil War because it comes up quite a bit, states' rights in that discussion. The Civil Rights Movement a little bit too, and again, a couple ways in which we see states' rights applied or not applied today. Now, what people usually mean by states' rights is they mean that they're looking for a decentralization of authority. And by that I mean people see that there's been a huge concentration of power in the federal government, that a lot of lawmaking happens there, a lot of action happens there, I guess. A lot of what we focus on in terms of government authority happens there, and states seem to have less and less say over how they're able to govern themselves. Someone in Georgia or Florida may want something different than what's going on in New York, but if Congress sets forth a law that says everyone has to obey a certain thing, like drug prohibition, for instance, then no state is able to get out of that. So, and we see that again with like Schedule I drugs, right? Like if there's a Schedule I drug, if no state can really allow that drug to be legally sold in those markets without facing penalties, and sometimes that's penalties in terms of withholding funds, or sometimes that means that citizens within those states, even if a certain activity isn't or is allowed, that the federal government could go after that state's citizens for it. So again, we've seen this concentration of law at the federal level, and what most people mean by states' rights is they think if the people of New York want to live a certain way and have a certain set of laws on drugs, on guns, on whatever, they should be able to set those laws. And people see that as a good because it's better to have government at a slightly more local level than at a distant, out-of-touch, bureaucratic mess out in Washington, D.C. And again, that's how a lot of law gets made nowadays. It's not even passed by Congress. It's passed by regulation. Now, so I'm pretty sympathetic to this argument that I really like the idea of states' rights in some regards, but I don't actually like the term states' rights, and I'll get to that in a little bit. But I'm going to keep saying states' rights because people are going to know what I'm talking about when I say states' rights. But okay, let's go back to the beginning. You know, let's pretend you have no idea how the U.S. system works, and let's go back to we have a federal government that is kind of an overarching system for the entire United States, and then we have several state governments, and that's where most law really is still made. There's more and more law getting made at the federal level, but most law is still made and enforced at the state level. So your laws like murder, theft, larceny, racketeering, whatever, any of those things. Most of it's happening at the state level, although some happens at the federal level. The drug enforcement stuff, again, mostly at the state level, some at the federal level. Gets a bit murky sometimes, but for the most part, we have a system that is federalized. So we have these quasi-independent states that are able to be quasi-self-governing. And that authority is listed in the U.S. Constitution under the 10th Amendment. And the 10th Amendment says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And what that means is that it's saying that if the U.S. Constitution doesn't specifically grant the federal government an authority, then that power is reserved to the states or to the people, of course. And going back in history, the framers worded things like this because each individual colony that ended up forming the Articles of Confederation and eventually the U.S. Constitution were seen as, again, states being actual self-contained, mostly independent governments. So these states kind of came together and formed the compact, forming the United States, and they used to refer to it back then in more of a pluralistic term, these United States, the states that are united. And again, they formed this federal government to do things like provide for the common defense and negotiate international trade, things like that. So these states were independent bodies who came together and formed this national government to do certain things that they thought would make them they would be better done together, right? So that authority is listed in the Ninth Amendment, the 10th Amendment, and that's where it comes from. And if you want a really good resource for kind of understanding the strong states' rights argument and some of that early history, I'd recommend the 10th Amendment Center. I used to be a big fan of theirs, so they're really interesting. But what's also fascinating from like kind of a historical perspective is how that started to shift over time, and where it's funny where I started to deviate from like the 10th Amendment Center stuff is over this thing called incorporation theory, so look it up. Do you think that the First Amendment, the freedom of speech, and the Second Amendment have always applied to states? Are states obligated to follow those restrictions on government? And the answer historically is no. Actually, a lot of states way back when used to have official religions. They used to do different things to limit free speech. The states didn't see themselves as obligated to follow the restrictions in the first 10 amendments of the Constitution because those were limits on the federal government and not the state government. State government was allowed to do what it wanted. That changed a little bit with the 14th Amendment following the Civil War, which kind of says that the states have to follow any right that is enumerated in another part of the Constitution for individuals, and it just says all persons born or naturalized in the United States and subject to jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. And so a lot of people have kind of interpreted that as, well, any right that's enumerated in the U.S. Constitution, any natural right of a person that we have saw fit to restrict the federal government in, we must therefore do with the state governments as well. So that's why the First Amendment and the Second Amendment in a lot of ways gets applied to the states. All right, when we come back, we'll talk a little bit more about some of the historical applications of states' rights. We'll talk to you then. Welcome back to Radio Free New York. I'm Kevin Wilson, again sitting in for Andrew Hollister today while he's on vacation. And today we are talking states' rights. And I want to wrap up the last section to say, again, I don't really like talking about states' rights. States don't necessarily have a right to anything, they just have a power. Only individuals have rights, and states cannot have a right that an individual does not have. And I think that comes into play quite a bit when we talk about states' rights in the context of the lead up to the Civil War. Now, this is where I see a lot of the biggest conflict come from, and especially when people on the left think of states' rights, they think of two things. They think of the Civil War, and they think of the Civil Rights Movement. And I want to talk a little bit about both of those today. Now, one of the common narratives I hear from conservatives, libertarians, people on the right generally, is that the Civil War was fought over states' rights. I'll tell you, the answer to that question is, well, usually my first response whenever someone says the Civil War is fought over states' rights, I would say the state's right to do what? And then I get an awkward silence because the answer is that the southern states, when people are usually thinking of that, they think that the southern states seceded because the northern states and the federal government were aggressing on the states' rights of the states in the South. And again, you have to ask, the state's right to what? Well, the state right that they wanted to have was to be able to make laws saying that some people could own other people. And usually paired with that is that the South wasn't really seceding over slavery. It was just seceding over states' rights and being able to be independent. But I'll tell you to go check out what's called the Cornerstone Speech. It was given by Alexander Stephens, who was the vice president of the Confederacy. And he makes pretty clear that they weren't seceding because they were in favor of states' rights. They were seceding because they wanted slavery. And I'm just going to quote from that speech a little bit because it's really interesting. So Alexander Stephens was talking about like the founding of the United States, and he starts to say the United States rested upon the assumption of the equality of races. This was an error. It was a sandy foundation, and the idea of a government built upon when the storm came and the wind blew, it fell. Our government is founded upon exactly the opposite ideas. Its foundations are laid, its cornerstone rest upon the great truth that the Negro is not equal to the white man, that slavery, subordination to the superior race, is his natural and moral condition. This, our new government, is the first in the history of the world based upon the great physical, philosophical, and moral truth. Yeah, so the Alexander Stephens was making pretty clear that the government that they were trying to build was based on racism. That's what it is. It's right there. Look up the speech. It was not about states' rights. It was about building a government around slavery. But that's not to say, and most of the states' rights stuff ends up coming from historical revisionism meant to make the South look like the victim in the Civil War, which, you can look at the brutality of the war, and I think it's a valid question to ask. Should states be able to secede from the United States? I think that's a valid question to ask. I think we should discuss that openly and honestly. Should a state be able to peacefully leave the United States and say, no, we want to do our own thing. We don't want to be under the laws of the federal government anymore? I think from a philosophical and political perspective, it's worth saying, like, if I don't know, Alaska decides, you know what, this doesn't make any sense. We're far away from the continental U.S. We want to be on our own, have our own laws. Okay, I think that's worth discussing. But I don't want to conflate that discussion about the nature of states, the state powers, state independence, secession. I don't want to conflate that with the morality of the South, because the truth of the matter is the Confederacy that formed in the run up to the Civil War was not an institution built on morals. They do not have the moral high ground in this fight. But what's really interesting is that states' rights, in its own way, do come into play in the lead up to the Civil War, but not in the way that you think. So, what was going on in the 1850s is that the northern states were the ones who were talking about states' rights. So, what the northern states were upset with is the passage of the Fugitive Slave Act of 1850, which required northern states and northern governments to make sure that they capture and return slaves who had escaped from slavery in the South. The federal government, which was at that time more or less controlled by the southern states, was compelling northern governments to act on their behalf, and the northern governments didn't want to do that. They were starting to enact nullification. They were starting to say, no, the thing that you're asking us to do to return enslaved people to their masters in the South is fundamentally immoral, and they didn't want to cooperate with it. And so in the 1850s, the people who were talking about the states' rights were people like the abolitionists. And that is funny, that tends to surprise people, but nullification can be used, and states' rights or states' powers can be used for good or evil. All right, so let me give you a specific example, and I'm going to read from this book. It's called The Causes of Civil War by Kenneth Stamp, breaking out my old history books here. And it says, the New Jersey legislature found occasion as late as 1852 to declare in solemn resolutions that the Constitution was a compact between the several states and that the general government had been granted by the sovereign states only limited powers. So the passage of the Fugitive Slave Act called forth fresh evidences of latent state right feelings in the North. And they passed what's called personal liberty laws. And again, the southern states at this time were complaining in the 1850s, before the breakout of the Civil War, the southern states were complaining that the northern states were asserting states' rights too aggressively, arguing that they were undermining the rule of law by nullifying the Fugitive Slave Act by refusing to enforce it. So again, you can use nullification and states' rights for good. In this case, I think the northern states are absolutely right to refuse to have their governments cooperate with the federal government at the time, and it could be used for evil too. Again, I think that when the southern states later on, at the outbreak of the Civil War, asserting that they had a state right to be able to preserve the institution of slavery, that's not right either. What I always err on is, does the assertion of states' rights maximize individual liberty? If the answer is yes, then I think that's generally a good thing. And if the answer is no, then I don't. And again, this discussion ends up getting tricky from a constitutional perspective because we have to look at both what's legal and what's right. Do states legally have the ability to be able to assert a state right and to ignore federal law in some instances in order to assert their moral authority? I don't know. In some cases, I think maybe, but in other cases, maybe not. And the federal government has various mechanisms for being able to get these states to comply with federal rules. Sometimes it's withholding money. Sometimes it's taking a more aggressive action. In the case of the Civil War, when the southern states tried to secede, the answer from the Lincoln government at the time was to use military force to try to keep the states in the Union. And and that's a tough one, right? Like, who is the best moral actor in that case, right? Was the most moral move for Abraham Lincoln to do that? And I want to be clear, because I know someone's going to be listening to this and it's going to come up to be like, well, Abraham Lincoln wasn't really there to stop slavery. And you're right, he wasn't. Abraham Lincoln was interested in preserving the Union at the outbreak of the Civil War. He was not interested in ending slavery. In fact, there's what was almost the 13th Amendment. It's called the Crittenden Amendment, was that states would explicitly, in the Constitution, have the right to enact laws that would allow for slavery. But again, getting back to the discussion of do states have rights, I don't think that any state has the right to include a law that allows one person to own another person. No state has the right to do that. Again, no individual has the right to own another person. If each individual person has autonomy, if each individual person has liberty and rights of their own, a state cannot delegate those rights to other people. A state cannot tell one person, yeah, it's totally fine if you use violence and coercion to keep another person enslaved and to take the fruits of their labor. And so that's what, whenever you're having a discussion about the Civil War and states' rights as they relate to kind of modern discussions, I want to caution you, because I see a lot of people doing this, from elevating the moral standing of the South, because the South is not, the Southern Confederate States are not good here. Just because they're asserting a constitutional principle does not mean that they were applying it to the end of maximizing liberty. States' rights, to me, are a means to maximizing liberty, not an end unto itself. States' rights aren't the goal. The goal is to maximize individual liberty using constitutional methods like states' rights, and sometimes things like nullification to do so. All right. When we're back, we'll talk about another way that states' rights often comes up as well. We'll talk about the civil rights movement a little bit, and we'll be back here on Radio Free New York in just a few minutes. Welcome back to Radio Free New York. We're talking today about states' rights, and we're just wrapping up the section on states' rights as they apply to the Civil War. But the other section, of course, the other portion of history where states' rights often come up is the Civil Rights Movement in the 50s and 60s. We see it start to bubble up, especially fervently, in the lead up to the Brown versus Board of Education stuff and the desegregation of the school system. And, you know, I was looking up part of what members of Congress are saying at the time. There's this Declaration of Constitutional Principles, the Southern Manifesto. It was written in 1956 and signed by 101 members of Congress. And they said that the federal judiciary is undertaking to legislate and degradation of the authority of Congress and to encroach upon the reserved rights of the states of the people in desegregating schools. And they go on to say that it's they commend the motives of those states which have declared the intention to resist forced integration by lawful means. And what they're saying is that they're asserting that the states of the South, which had a segregated school system at the time, had a constitutional right to be able to determine how they want their education administered, and that the federal government had no right or authority to be able to say that they must integrate the schools. And so this is another situation where we see states' rights asserted on behalf of, I think, diminishing individual liberty. Because what you had in the South was, again, state governments, the government enforcing segregation. It was not merely a matter of cultural practice, which existed in the North and in some ways exists today still. It was the law. it had the force of the state behind it. The state said you cannot have integrated schools. The state said that you cannot have integrated water fountains and lunch counters and stuff that to most people today seems ridiculous. And that African Americans and white Americans as well in the South had to fight very, very hard to get their state governments to repeal those ridiculous laws, and that when the federal government intervened on their behalf, these states resisted it. And one of the most fascinating and vivid displays of this states' rights principle, I think, misapplied and applied in a way that I don't like, is the Little Rock standoff. So in this situation, after the Brown versus Board of Education decision, Little Rock Central High School in 1957 was supposed to integrate, but the governor of Arkansas at the time, a guy named Orval Faubus, stood out and tried to prevent these African-American children from attending this previously all-white school. And it ended up escalating into a pretty serious thing where the National Guard was called out. There were protesters. I mean, the people in this town were really nasty to these young children and throwing epithets at them, throwing objects at them. And the governor at the time ended up calling out the National Guard to actually prohibit these children from entering the school, which is bonkers. But President Eisenhower ended up sending in federal troops to enforce integration and protect the United students. So there's kind of standoff with the Arkansas National Guard and the federal troops who are coming in to enforce this desegregation. The 101st Airborne Division was there. Oh, it's interesting. I'm reading the Wikipedia article on it now, and it says without black soldiers, an all-white unit. And they went to Little Rock. They federalized the 10,000-member Arkansas National Guard, and they took it out of the governor's control, and they ended up making sure that those students were able to attend school. So I think where this situation gets interesting, and I think it's worth asking, which level of government in this case was better at making sure that individual liberty was possible? Is it the state or is it the federal government? When a state government is doing something like passing these laws, these de jure rules of segregation where African Americans aren't able to, again, attend social functions, they're not able to access services offered by the state, they're not able to make private transactions, when the law itself is ensuring that individuals aren't able to be treated equally, and that, again, any law comes with the force of violence, then is the federal government obligated, or right at least, to intervene on behalf of the individuals who are being affected? And this kind of comes back to what I had talked about in one of the other sections with incorporation theory. The 14th Amendment says that the states are supposed to respect the rights of citizens, that all citizens are created equal. And that includes applying all these rules. So if a state is going to take your tax money and apply that to the education system, then every citizen of that state needs to have that same right. The same, if they're paying their taxes, they have a right to be able to get an equal share of that education, and they can't. Again, I'll quote from the 14th Amendment: "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Now, again, this amendment ended up happening in the immediate aftermath of the Civil War, but if you know anything about U.S. history, that didn't get applied in any sense for quite a while. But even if you're trying to make the argument that, okay, well, these states have a right to govern themselves, I think it's really tough to say that the southern states at the time were in any sense a democracy if the African American citizens were denied the right to vote in those states. And that was often the case, and that activists in those areas would often risk their life and limb, literally getting killed in some cases, to try to help African Americans register to vote in the 1950s, 60s South. And maybe even a little bit beyond that, maybe into the 70s too. But in a lot of these cases, they were getting shot at just for trying to do voting drives. So if African Americans aren't able to even participate in that democratic process, how can you say that a state's decision reflects the will of the people? How can you say that a state ought to be able to deprive certain citizens of their rights, liberty, and equal enforcement of the law when they don't even have the ability to be able to participate in the process of crafting those laws? So I think it's worth asking, again, should the federal government sometimes intervene in the powers of states if it means that it's going to maximize the liberty of individuals? And I don't have a definitive answer to that, although I want to talk about in the next section a few cases where that might apply. I don't know. My answer for a very long time was, well, I'm a states' rights guy. But I look at cases like this, and that's tough. I think that maybe there's some cases where the federal government, if they're actually acting on behalf of the individual, which I think is pretty rare, is right to get involved. And you can see this in I want to say a Second Amendment case. Go look up the case. It's called McDonald versus City of Chicago. What that ruling said was that the Second Amendment, the right to keep and bear arms, as protected under, under Second Amendment, is incorporated under the 14th Amendment against states, right? So again, that states and local governments, so Chicago, are obligated to follow restrictions that are put on the federal government on behalf of individual liberties. So again, the First Amendment restricts the federal government from making laws on speech and religion. Second Amendment restricts the federal government from making laws depriving someone of the right to bear arms. The McDonald versus City of Chicago case made it so that the federal government, or that the city government of Chicago, couldn't deprive individuals of their right to bear arms. So definitely check that out. That's another case where the federal government intervened to protect individual liberty against local control. All right, we'll be back in just a few minutes with our last segment, and we'll talk about where do states' rights apply today. Talk to you in a few. Welcome back to Radio Free New York. I'm Kevin Wilson, subbing in again for Andrew Holzer, and we're talking about states' rights. And I've complicated matters. We've looked at cases where, hey, maybe the federal government intervening, if it's on behalf of individual liberty against state rights, maybe that's okay. But I think that's usually the exception, not the rule. And I want to talk about ways in which states' rights are still part of the conversation. States' rights and kind of nullification or at least resistance to federal authority coming from the state and local level is something that's still happening. And I think there are two very visible ways in which we see this in the media. One of which is starting to succeed. We've seen it over the years, is that states over the last 30 years have started to resist the federal prohibition on some drug laws, specifically marijuana. Again, marijuana is a Schedule 1 drug still from the federal government that the federal government does not allow, the Schedule 1 means that there's no medical use for this product. Marijuana is totally legal from a federal perspective. There are occasionally bills that come out, and last I checked, I think this hasn't gone through, but there are bills that come out that maybe will let people start banking using funds gained from marijuana sales because several states have decided to say, you know what, we don't care what the federal government says. We think that this does have a medical use, or we should allow recreational use, and we'll just sell it, tax it, let people do their thing. You know, states like California for decades now have had medical marijuana. People can go and get their medical card and get a marijuana prescription. Colorado was one of the first states to legalize recreational marijuana. So in Colorado, even though they tax it pretty heavily, and in all these states have legalized it, they are able to go and just buy it for their own enjoyment, which, again, that's something that I like and I appreciate. And New York is, as of making this episode, is still considering whether or not they want to allow legal recreational sales of marijuana, but they do allow medical sales of marijuana. So if you, again, get a prescription for it, you can go to a few state-approved vendors and go buy marijuana. Now, all these states are doing this in defiance of federal law. Federal law still says that marijuana is illegal. Now, technically, at any time, federal agents can come in and raid these places if they so choose. A lot of them don't. The federal government, for the most part, across several administrations now, have decided to more or less leave these states alone. But they could, at any time, change their mind and start enforcing federal marijuana prohibition and raiding these otherwise legal dispensaries in the states. So this is one of those cases where, again, states are allowed to set their own rules. They're able to govern themselves. And in this case, in defiance of the federal government, they're able to make laws that they decide are the best fit for citizens. And in this way, I think states' rights are being applied to protect the individual liberty of people residing in those states. Individuals, to me, and in my opinion, they should be able to smoke marijuana if they so choose. And I know it's not good for you in a lot of cases, but it's your body, it's your choice. You're an individual. You own yourself. If you want to be able to smoke marijuana, that's your business. And I think at the very least, you shouldn't be sent to jail for that. And I don't think that's an unreasonable position to take. So again, some of these states have started allowing the commerce of that, and that opens up new opportunities for businesses to flourish. If you're looking at it this way, it's an opportunity to generate tax revenue. It's an opportunity to change the criminal justice system in a way that's not really expensive. So states' rights are being applied in a way that I think are really good. And we're starting to see, again, a trend that the federal government is following the leads of these states, where they're starting to say, okay, maybe we won't enforce federal marijuana prohibition. Maybe they'll start peeling back restrictions on banking soon. So again, any federally insured bank is not allowed to take funds received from marijuana sales. They've already rolled back some restrictions on hemp, which doesn't actually have any psychoactive properties anyway. They've started to roll back restrictions on CBD oil because they've seen some of the medical uses of that. So the federal government is starting to follow the states in some cases over the last 20, 30 years on rolling back restrictions brought on by the war on drugs. And I think that's a positive step for liberty, and I hope to see more of it. Another interesting case that we may start to see in the future is more sanctuary states. And I think that depending on who you ask and in what context you ask them, that can mean two different things. If for some folks, a sanctuary state or sanctuary city might mean that they aren't enforcing immigration restrictions. That they disagree with the Trump administration or even the Obama administration previously on the enforcement of immigration laws, and so that they are not going to cooperate with the enforcement of those laws. It might also mean a Second Amendment sanctuary. I think that's another case where that might be applied as well. We had kind of discussed the McDonald versus Chicago decision, and even though the Supreme Court has said that local governments are under incorporation theory, that they have to follow the same restrictions that the federal government does on the Second Amendment. A lot of places, the federal government is always looking at, the Congress is always looking at greater restrictions on the Second Amendment. States, of course, and Andrew's done some great episodes on Virginia are doing that, and now we're seeing these things like sanctuary counties where county governments are saying, no, we're not going to comply with the enforcement of these laws. They're gonna nullify them in their own way, and I think that gets trickier from a constitutional perspective because you don't have that weight of, well, the states form the federal government, therefore the states have priority in enforcing the laws and deciding what laws they want to enforce under that agreement. But I think the principle is still sound. Again, I'm all for resisting federal and state authority when it means doing so on behalf of the individual. Not that there's no consequences for that. And again, I do want to touch on the immigration thing because that's what's so fascinating. I get some of the biggest, whenever I mention states' rights, and I've given you a pretty nuanced view of this, but whenever I mention states' rights, progressives freak out and they think about the Civil Rights Act, and they think about the stuff I talked about in the last segment where they see states' rights as being applied to oppress the rights of minority populations. And what we're seeing today, though, is we have states like New York and other states and local governments like the city of Rochester, where I live, that are sanctuary counties. And what that really is that's an assertion of states' rights. That's nullification in a lot of ways. So what they're doing is these local governments are saying that they're not going to cooperate with ICE and immigration enforcement authorities, because how it works right now is if someone is detained, ICE can make a detainer request and ask for a sheriff's department or a local police force to hold someone in custody until they're able to come pick them up. Now, the city can't compel a local police force, again, a sheriff or a police department, to enforce immigration law and to go out and pick up people that they know are illegal, have overstayed their visa, undocumented in some way, but they can, again, threaten to withhold some funds in this. So there's a risk that local police departments or sheriffs or state police departments could lose some funds by not cooperating with federal authorities, but ICE can't really make them comply. So again, what local police forces do is they just say, no, we've picked this person up. We're not going to inquire about their immigration status. We're just going to release them on their own recognizance or do whatever, depending on the nature of the crime, right? If they pick someone up for murder, then it's probably a bit different. But it's interesting to see that these communities, Rochester included, have decided to resist federal authority. Because, again, resisting federal authority is something that comes off as kind of a libertarian, wacky thing that scares the crap out of Democrats. But that's exactly what they're doing here. What they're doing is, New York State is asserting a states' rights or a states' power position. Same with City of Rochester, saying no, we're going to defy federal authority in this case. And so that's something. If you're someone who thinks that the idea of states' rights is generally good when applied in the correct way, and you run into a progressive who absolutely freaks out and can't think beyond the civil rights movement in regards to states' rights, just think about the ways in which it could be applied in a positive manner. And, they might think of that in a positive manner. They might think of the ending of the prohibition of marijuana as another positive development. And again, that was propelled forward by states' rights. So, and I think that cities absolutely have the ability to be able to not dedicate resources to something that they disagree with. That's fine. Again, that's nullification. That's a good thing. And to me, and I think that is an intervention on behalf of individual liberty that I'm in agreement with and that I'm happy about. All right, I think our time is about up. Thanks again for joining me today on Radio Free New York. Let me know what you thought of the show. Send me an email, contact@radiofreenewyork.com if you have any feedback, or leave a comment on our Facebook page. We'd love to hear back from you. Thanks again for joining me here on Radio Free New York. We will be back again tomorrow. Take care.